So, just to set the stage of what we're going to do today, this is 9:15 a.m. and I've been allotted 1 hour to speak, so I will speak for 1 hour or less. But the way I have determined to approach today's or this morning's session would be to spend 20 to 25 or 30 minutes on these slides, and then the remaining 30 minutes I want to give sufficient room for questions, not just on the slides, but I suppose for even previous sessions that we've had together. I am cognizant that there's a chance that perhaps there are questions that have been left unanswered. Fortunately, Rabi was kind enough to address two of the two cases yesterday, as you will be aware, and we looked at Ghana and Zambia, and for that purpose, or for that reason, I would not be reiterating what he has already done. We had one final case study, and I think it's from Chad, because Chad is one of the other countries that has, in fact, Chad was the very first country that used the common framework. And the reason why we wanted to highlight Chad specifically was because of how Chad approached the common framework and what lessons we can learn. We've already seen what lessons to learn from Ghana, and we've seen from Zambia, which was done yesterday. And so if you have any questions, okay, so you can see it's Chad, Zambia, and Ghana. So if you have any questions, please let me know. And it doesn't have to be just from today's session, but also from previous sessions. Okay, so these are just a few facts, and I think I will just dive right in. As a matter of fact, I will speak for a bit and maybe invite delegates from Chad to provide further perspective on, what has happened in their country under the common framework and what lessons they think could be relevant for any other country who will probably engage the common framework sometime in the future. So this is just a bit of stats on what happened. And with Chad specifically, Chad was the first country, as you can see on the screen, to request a death treatment, the first African, I think it was the first country globally actually, to request a death treatment under the G20 framework. And the big concern with Chad was that their exposure at the time was just about $3 billion US. The concern was a third of that amount was owed to a private commercial creditor whose holding was linked to commodity reserves. And I believe yesterday there was a question from the delegates, I'm not sure if it was from Burkina Faso or from Guinea, about commodity-linked loans and how to deal with them during restructuring. Well, that was the situation with Chad. And in fact, one of the biggest takeaways from Chad's restructuring was not just that it was commodity linked, but because it was commodity linked, it proved quite difficult to restructure. And the reason was because the private commercial holder of this commodity linked loan in Glencore at the time did not want to budge in terms of how much they were willing to take in the restructuring. They were happy to reschedule, or more appropriately, happy to reprofile, to extend maturity, but not to take a haircut. And obviously, this was the first time that, as you are now aware, both Paris Club and non-Paris Club creditors could come to the same table to discuss. So whilst Glencore wasn't on the same table with official creditors, they were having parallel discussions with Chad on the side. And one of the things that the official creditors sought to do was to come to a point of agreement, a memorandum of understanding. And for China, this was a new landscape because they hadn't, prior to the common framework, ever had to negotiate side by side in this way and to this degree with Paris Club members. And so their official creditor committee was constituted by, I believe it was France, Saudi Arabia, and China. And China was really pulling back to restructure in a way that would amount to haircuts. And of course, Glencore was watching and also saying, we are not going to take a haircut. At best, we can take a reprofiling, an extension of maturities, as opposed to a full-on haircut. What made this discussion between Chad, or with these dynamics between Chad, China, and Glencore even more telling? So what makes the dynamic between Chad, China, and Glencore even more interesting was because the loan was linked to commodity, which is oil. Oil prices, so at the time that this whole conversation started in 2021, oil prices had crashed just after around COVID. And so it was almost clear to observers that Chad would require some haircuts. But by 2022, whilst the conversations were still ongoing, oil prices began to pick up. And then Glencore doubled down and said, well, oil prices are picking up. We believe that based on these oil prices that are picking up, Chad will be able to come up with the revenues needed to pay us back. And on that basis, all we can accept is a reprofiling or an extension of maturity of this loan as opposed to a significant or any reduction at all. And this underscores the problem with commodity-linked loans during restructuring. And so I noted here that a key positive was that it avoided outright default and set a precedent for creditor cooperation. And like I already mentioned, China was now on the table and other non-traditional Paris Club members. But the commodity price risk, so oil price assumptions played a major role. Creditors denied a haircut due to rising oil prices, leaving Chad vulnerable if the prices dropped again. And this is the problem. So the reason why they were refusing to participate was because the oil prices were increasing, so they figured your revenues would increase and then you can pay us back in due time. No need for haircuts. But what if the oil prices fell again? And the key takeaway from Chad is Chad's restructuring exposed common framework's early limitations and the complexities of negotiating with diverse creditor types, as well as reinforced the importance of commodity price assumptions in debt talks. And so like I advised yesterday, when you have commodity-linked loans or debts, one way to deal with it during a restructuring is to ensure that there is a clause that says when the commodity goes up, you pay more. When it comes down, you pay less. And this is what we refer to as a commodity-linked bond or commodity-linked clause. And that could have been added to Chad's portfolio. But I wanted to check if I will just finish and then ask if any of the representatives or delegates from Chad wanted to add some more color and give us, perhaps to the extent you can, and feel free to redact information, the updates, what is going on, and how are we looking to deal with the aftermath of this restructuring. So lessons from Chad include slow coordination. You can see Chad's case highlighted early common framework inefficiencies, with creditor coordination proving slow and delays drawing criticism. We've already talked about the fact that, common framework, whilst it is quite organized, for the first time it has brought both Paris Club and non-Paris Club creditors to the same table to find a memorandum of understanding. It's also very slow because competing interests do not deter or are not factored in by the framework itself. You have to deal with that as it comes. Another thing that we see as a lesson is private creditor challenges. And so even if the common framework brings together official creditors, bilateral creditors, it doesn't necessarily address the issue or the drawbacks of having private creditors within your restructuring perimeter. Remember, as we discussed on Tuesday, that the number one goal of the private creditor is not just to get his money back, but to get that money back with interest and the complete interest. So they are always quite more difficult to deal with. And we'll go subsequently to how the world is responding to dealing with this issue of private creditor drawback during restructurings. And the last thing is limited relief. Even though we can see now with Ghana, with Zambia, that there is a lot more possibilities of relief that can be gotten or obtained under a common framework restructuring. But for Chad, one of the key precipitating factors, according to the reports, on why they had limited relief was because of that commodity-linked loan and the difficulty with dealing with that conversation with the creditors. So this is the timeline. We said the request was in January of 2021, the common framework request, and then the creditor committee composed of France, Saudi Arabia, and I believe China was constituted 4 months later, and then the final deal was done in 2022, with preliminary deal in June of 2021. So it took about roughly, almost 2 years, say 22 months to get Chad's restructuring figured. I wonder if anyone from Chad, in 2 minutes, please, wants to add and correct any of the assumptions here, or add more color, or give us some status updates. Do we have any takers? Where's Chad seated? I can't even see them.
Ok, merci de me passer la parole. Je voulais aussi ajouter certains compléments par rapport à la restructuration de la dette du Tchad dans le cadre du G20. J'espère que le premier jour, nous avons parlé un peu de ce qui a poussé le Tchad à restructurer sa dette. Il était question de restructurer la dette à cause du prêt Glencore qui occupait une part très importante dans le portefeuille de la dette du Tchad. Et le prêt était gagé sur les ressources pétrolières. Et le service de la dette extérieure occupe une part, surtout la part qui revient au Glencore représente 1/3 du service de la dette. Et selon la convention, si le prix du pétrole augmente sur le marché, cela va pousser le Tchad à rembourser plus rapidement le service de la dette. Et en cas de choc sur le prix du pétrole, le remboursement sera moyen. Et comme étant encore sous programme avec le FMI en 2021, il était question de rendre la situation de la dette soutenable. Alors, les autorités ont pris des décisions, ils ont échangé avec les différents créanciers. S'il y a lieu de restructurer cette dette, alors dans le cadre du Club de Paris, sous l'égide surtout du FMI, qui a mis un peu de pression sur Glencore. Glencore n'était pas disposé à entrer dans le cadre parce que les négociations étaient vraiment difficiles. C'est ce qui a fait que la durée de la négociation est allée au-delà de 2 ans. Et c'est vers la fin, d'autres créanciers ont dit que, bon, comme le prix du pétrole était élevé, est-ce que le Tchad ne peut pas rembourser, ne peut pas anticiper le remboursement de cette dette? Alors, comme le prix du pétrole était volatile sur le marché, il était question de trouver des cadres ou des garde-fous pour que le Tchad puisse honorer vraiment ses engagements. Alors, le comité de créanciers s'est convenu.
Could you please round off because of time? But thank you so much, some helpful information so far.
OK. Donc, le comité s'est réuni et ils ont trouvé un accord. Et comme le prix était élevé, et c'était vraiment bénéfique pour le Tchad, ça a permis à ce que nous puissions rembourser presque 3/4 du service de la dette qu'on doit à Glencore. Alors, je pense que le cadre a été bénéfique, ça a permis à ce que nous puissions honorer nos engagements et également le club de Paris était vraiment très efficace dans les négociations et ça a permis à ce que nous puissions avancer dans ce processus. Et actuellement, je pense que le taux d'endettement du Tchad a baissé, considérablement baissé, parce que nous avons remboursé énormément ce prêt envers Glencore. Voilà les quelques éléments que je pourrais apporter par rapport au cas spécifique du Tchad. Merci.
That's very helpful. Thank you. So I think very key points he made and much aligned with what I had already established. What I find really interesting is that there was not really a haircut, just based off of that oil price growth. You were able to pay back on that arrangement of commodity-linked clause or bond, and I think that's what Chad did for the delegate who asked the question yesterday. They implemented a clause that allowed them to pay more as the prices went up and pay less as the prices plummeted. So we'll just skip this in the interest of time since we discussed this yesterday already. Thanks, Rabi. And again, you will get the slides anyway, and then you'll see. Comparative lessons? Okay, try to do, but you would see this. But maybe I should just emphasize this. And so I noted here that Chad taught us that even a small country's case can be drawn out if one big private creditor isn't on board. Also that the common framework can result in rescheduling rather than actual write-off, which may not solve the problem long term. But it seems that in Chad's case, it sort of solved most of the problem because the oil price clause was able to assist with payment structure. It was also a wake-up call that the common framework needed fixes and the delay and lack of clarity on private sector engagements. And Zambia highlighted the China-West creditor tensions and the domestic versus external inclusion debate. It's ending with a comprehensive deal, but after a painful wait, spurred reforms, and we get to these reforms. Ghana showed a proactive path, tackling domestic debt head-on and coordinating official creditors swiftly to shorten the agony. It also underscores the impact of political will. Ghana's government moved decisively. And unlike Zambia, whose previous government in 2020 was slower to engage. So these are comparative lessons, and we can pick it up on the slide when we get it. Recent reforms, and I just want to dwell on this a bit. So we've talked about the common framework. We discussed this yesterday, and some of the concerns that we have are delays, sometimes the extent of relief, and the IMF and the World Bank, but I think specifically the IMF, came up with revised policies on how to deal with the common framework, especially in cases of restructuring. And one of the things that they've done in a policy document that was released in around 2024 was to clarify the lending into arrears policy. And effectively, IMF's position is that it will clarify when it wants to lend into arrears, even if there has not been an actual agreement between the official creditors and maybe the debtor. And so previously, IMF would typically, or under the previous framework, IMF would wait for there to be an actual agreement before it would lend into arrears. But IMF is saying now that if a country negotiates in good faith, but creditors are stalling, the IMF may still lend under specific conditions to pressure the creditors to act. So again, this is to help the process move faster. There's also financial assurances reviews. And so once the program is approved, the IMF will monitor close debt talks at each program, signaling concerns if negotiations stall. Again, the IMF's approach has been, we want to be a bit more proactive. We want to be a bit more engaged and involved in the process so that things can move on swiftly. We have not seen a new request under the common framework since 2023, I believe. And so perhaps when we see the new request, we'll see how IMF would act, hopefully in accordance with its new principles. Because all of these principles were really established post-Ghana, post-Zambia, are some of the lessons that were learned in those restructurings. And so there's also a new approach to creditor assurances, which is on the slides, and I do not want to insist on that. So typically, as you know, because the IMF and some of the multilateral creditors who are preferred creditors cannot be brought within the restructuring perimeter, the general approach is that if you are debt distressed and you're undergoing debt restructuring and you have arrears to a preferred creditor, you have to settle those arrears before IMF can lend to you. But then IMF has come up with a new policy that says if there is an extreme emergency, such as a natural disaster, to the country who is restructuring, they will lend into arrears even if those arrears are owed in favor of preferred creditors. So this is a high-level extreme exception, but this was not existing previously. I think the clicker, okay, it's moved. That's it? Okay. So also the G20 have reacted or has reacted to the delays in common framework. And one of the things that they've, first they've been blamed because the common framework is their brainchild, but also they've reacted to this blame and come up with a new set of guidelines on first the lessons that they've learned and some of the things that they will take forward in fashioning or in improving the common framework. So do not be surprised if by December, when we have the next G20 meeting, we'll see a revised or a common framework 2.0 come out. And so it says here that some of the lessons learned and potential changes one can expect regarding the common framework going forward are, and this is in the G20's websites of what they're looking to implement on the common framework. So again, as you know, the international financial architecture is constantly improving. And I was talking to Dr. Ayikuta yesterday and of how a lot of the changes we are seeing are not cast in stone. They are constantly being improved. And so it's very important that as debt managers, we are also on top of the issues. And so it says clearer step-by-step guidelines and timelines to provide predictability in the restructuring process and reduce uncertainty about how long each stage takes. So under the common framework, first, you would have approached the IMF, and then after the IMF has approved the program, you would then go towards engaging your official creditors to the extent that they exist within your restructuring framework. And after that, in parallel, you first get an MOU, and then you get your private creditors on board, get comparable treatment, sign bilateral treaties, and then also sign either bond exchanges or amended loan agreements, just as we discussed yesterday. Now, what the G20 is saying is that they want to produce a timeline of how long each of this process, so that we don't have a Zambia that took 3 years, a Chad that took 2 years, and a Ghana that took roughly 18 months. But we have a more predictable timeline as to what happens, when, how long, and why. So it says here also that a comparability of treatment reference paper to ensure all creditors, including private ones, align on relief levels. So prior to now, comparability of treatment, even though there are defined metrics, and Rabi did a fantastic job yesterday describing these metrics, already exist, there is still, to some extent, struggle amongst creditor classes as to what is exactly comparable. And so we are expecting a revised or expecting a reference paper from the G20 on how this will be improved under the common framework. Then there's going to be improved data sharing, greater flexibility, and you see, so some of the steps we mentioned that the IMF is already introducing, we would have those implemented at the next G20's either reference paper or policy documents. So I noted here that by 2023, there were some positive signs. Ghana's relatively fast progress under the common framework and quicker provision of financial assurances in cases like Sri Lanka, though not a CF country, suggests that lessons from early cases are being applied. So like I said, we might see a common framework 2.0 with improvements on speed and inclusivity. So it's a work in progress, but we are getting there. Yes, I want to dwell on this a bit, and I think I have 5 minutes before questions. So you may have heard, but if not, I have to flag that there's a few developments that are ongoing within the United Kingdom and New York. As you will see on the screen, so specifically, these two jurisdictions, as you know, most international bonds have their governing laws and jurisdictions in New York or England and Wales. And both jurisdictions have come out to say, perhaps we can contribute our quota to how debt relief can be hastened. One of the biggest clawbacks, as we heard from the gentleman from Chad, is that if there's a private creditor involved, there may be a bit more dragging out of the process. How do we get private creditors on board? And so the parliaments of England and Wales and the parliaments of New York are considering bills that first insist that a commercial creditor cannot come to their courts to sue for a higher amount that is less comparable than what the official creditors have agreed. So essentially enforcing the comparability principle so that if your loan is governed by New York law as a commercial creditor, say Glencore for instance, and then under the IMF program and the MOU, it has been agreed that a certain amount will be given as relief, and Glencore is insisting they want more. If that agreement is governed by New York law and Glencore goes to New York, the New York courts will deny Glencore and effectively force them to accept what the official creditors committee have stated as a baseline. Now, I have to flag, as of March, I was listening in on the hearing in Parliament in England, and it has passed to the next stage of the bill. I think it's in the third stage of bill reading now in England. In New York, it's a bit more convoluted, and that's because there's been no agreement per se as to whether this should be adopted, but it is still in progress. It's currently in Parliament, it's still being read and being discussed. The concern we have is if for any reason England passes it and New York does not. Because what that would do is that, of course, commercial creditors will begin to insist that any new bond or new loan will be domiciled or governed by New York law and not English law. Right? But we'll see. I'm not an advocate for any of the jurisdictions. So the bills in New York, I took the liberty to explain what each of them will do. So, for example, the first one says the court will not accept to hear a claim brought by a creditor who had purchased such claim under specific conditions akin to those used by so-called vulture funds. The whole aim of this Champati bill being considered in New York is that if a creditor purchases a loan or a bond exposure to a sovereign with terms akin to what vulture funds would typically do, the courts will not hear that matter. And then we see it's all here. The banking bill says it creates a comprehensive procedure. So the banking bill aims to have like a bankruptcy procedure. Obviously, there have been a lot of pushbacks academically. How do you want to enforce an international agreement by compelling a particular framework for enforcement? It remains to be seen, but these are some of the things, some of the ambitious steps to be taken by Parliament, by New York Parliament. Okay, so you see some legal experts question that such laws could increase borrowing costs, obviously. If borrowers know that they can be compelled to accept a particular predefined outcome, like whatever is comparable to the MOUs of the official creditors, they may, of course, want to increase borrowing costs. So that's a concern that scholars are warning about regarding these interventions from the UK and the US. And I already made that point. If only the UK acts, holdouts will simply ship lawsuits to New York. Okay. So one of the points that has been made by scholars is also that even if these laws are not passed, the mere fact that they are being discussed can influence the behavior of commercial creditors moving forward. But again, we'll see. Oh, we're there. Okay. I'm actually right on time. I have 30 minutes more, but I will just talk through some of these. So what this means for you is speed and predictability should be the guiding principle. Use instruments like approval in principle and financial assurance reviews to avoid drawn-out delays. The IMF has improved this, as we talked just now, so engage them to the maximum extent possible. Comprehensiveness is key, and so Ghana's success shows incorporating domestic and external debt and involving all creditors makes a deal more credible and swift. But obviously, we discussed yesterday some of the drawbacks of including domestic debts. But like Rabi also indicated, there are certain cases in which it is just impossible not to include domestic debts. For example, if you have no fiscal room to even go forward, to even pay your domestic creditors, you probably at that situation would need to include them. But recognize that if the external creditors feel that everyone is sharing the burden, they will far more likely be more likely to cooperate with your restructuring agenda. And so, why does creditor inclusion matters? And so, China's role in Chad and Zambia illustrates the importance of early engagement across creditor types. Again, Chad and Zambia, this was the first situation for China, for the most part, and also for the countries who are having to deal with this framework. But engaging them early will be very helpful. Legal certainty builds confidence. It says here, stay updated on collective action clauses, drafting protections, and national legislative developments to mitigate holdout risk. It's not just for lawyers, and I understand if you come to the conclusion that, oh, this is too legal, I don't want to be embroiled in this level of complicatedness. If you come across any updates, it's okay to forward it to your legal department. Say, this is an interesting development. Please read and provide us a summary of what we should be taking note of. And institutional readiness is essential. So your ministries, your central banks, audit institutions should have well-practiced protocols, robust data systems, and public communication strategies to maintain and manage expectations and trusts. I believe this must be the very last slide. Great.